Anyone who's been living in the UK or has had an interest in immigration law or immigration rules would have heard about human rights. What are these human rights? Generally, people ask these questions. They don't understand what human rights entails. You know, somebody will say, oh, this is so unfair. This is against my human rights. And when you ask them to articulate that further, they have absolutely no idea how it works. So what I'm going to focus today is the human rights aspect of things in the UK and also how it affects almost every application that is made in the UK, and how, if you do not meet the requirements of the immigration rules, sometimes human rights are your best friends. So let's get into it. First of all, what human rights are we talking about? Now, we talk about Article 2, Article 3, Article 5, 6, 8, all these different articles that are there under the Human Rights Act. I'm not going to go into all of those because, strictly speaking, for immigration law, all of them are not applicable. If you're talking about asylum law, for example, you might say Article 2 and Article 3 might be relevant. And, of course, Article 8 could come in, Article 6 could come in. What do they say? Article 2 is prohibition of killing. So you cannot be killed. You cannot be at a threat of losing your life. That's Article 2. Article 3 is talking about inhuman and degrading treatment. So if you are subjected to inhuman and degrading treatment, if you're not being taken care of, or your mental health or your physical health is suffering, that comes under Article 3. If you're talking about Articles 5, 6, we're talking about access to justice, access to liberty, and all of those things. Article 8 becomes the most relevant one because it talks about private and family life, and that is what I'm going to focus on today. Now, what happens in the immigration rules? If you can meet the immigration rules, for example, you are legally in the country, you have a legal student visa, for example, you've completed your student visa, or you've completed your course and your visa is coming to an end, you have been offered a skilled worker visa and you want to switch to that. Follow the rules under the immigration rules. If you are able to do that, you are able to switch onto the other category. No human rights needed or involved or considered. Now, look at another situation. You are legally in the country and you want to now switch over as a spouse, but you are not able to meet the financial requirements. Ring any bells? These things are going to be becoming very relevant very soon, because as you know, the government's plan is to increase the threshold of income from 18,600 to go up to 38,700 pounds or more. So if that were to come into place, a lot of these cases would become relevant where you cannot meet the financial requirements, but there is an existing family life. There is an existing structure of the family. So there is a husband and a wife, or there are unmarried partners who've been living together for more than 2 years. They want to have that relationship recognized by the immigration rules, and then one person be granted status on that basis. But if you cannot meet the financial requirements, then you fail the immigration rules. But what happens then is we fall back on the human rights aspect of things, where we say, well, look at the situation. Look at how long they've been together, how intense their relationship is, how they are involved with each other. Maybe they have financial dealings together. Maybe they have been living together for a very long time. Maybe they have children together. Whatever those elements might be, we bring those in and then we go again. So what happens is, and what I want to discuss today is how human rights are involved in various applications. So I've just given you an example right now of the spouse visa. So if you are not able to meet the financial requirements, but you have an existing family life together, you can rely on that and you can apply on that basis. Now, what happens is, if you do not meet the financial requirements or any other requirements of the spouse visa, then you will not be put on a 5-year route to settlement. But if your case succeeds under the human rights element, you will be put on a 10-year route to settlement. So you will be granted 2.5 years, but instead of applying for indefinite leave after 5 years, you'll have to wait for 10 years before you're able to apply for that indefinite leave. Now, the other thing that comes in immediately, which you should know and which a lot of people ask about, is if you have been granted leave on the 10-year route, anytime that you are able to meet the financial requirements, you can make another application and switch over to the 5-year route. So this is always going to be an option open to you. So remember in the last video where I had spoken about this and I had said that this is not something which is the end all. There are always other options. You can look at other surrounding circumstances. You can look at other things that are applicable in your case, and those could be helpful. So this is one of those examples. Another area where this human rights element comes in is with the overstayers. So let's look at an example there where a student came to the UK. A lot of these examples come to me. I came in 2010, I came in 2011. I had a student visa. My college shut down because between 2011 and 2013, 2014, a lot of this was happening where people would come on student visas and then they would find out within a few months their college would be revoked as far as their sponsorship license was concerned. And because the license was revoked, they could not sponsor the student anymore. And the student had to run around, try to find another college, another university, another establishment where he could switch his sponsorship. And a lot of times they could not do it because either the rules would not allow it, or the second establishment that they would go to or the third establishment they would go to would also lose their license. So a lot of this was going on, and a lot of those people ended up as overstayers. And I deal with those consultations on a daily basis where every day I will have 1 or 2 or 3 consultations where people are in this kind of situation where they have been in the UK since 2011, 2012, 2013. They do not have legal status and they are still in the country. So what happens in those cases? We do a leave to remain application. First of all, I always tell you, you do not fall under the immigration rules. Rules say what? Rules say either you've spent 20 years in the UK, legally or illegally, does not matter. If you're able to prove that you've spent 20 years in the UK, you can apply for your leave to remain. Or you have spent more than half your life in the UK and you're between the ages of 18 and 25. Now, if that applies to you, fantastic. Again, you'll get your status. But if not, look at the next one. Next one is that you have a child living with you, your child living with you, who has spent more than 7 years in the UK and is still under 18 years of age. These are the 3 main categories under PL, Appendix PL, where you are able to get leave under the private life route, which is the human rights element under the immigration rules. The 4th category is you've not spent 20 years, you've not got a child with you, you've not spent half your life in the UK, but there will be significant difficulties in you settling back in your country. Now, when I say to you that you do not fall under any of the immigration rules, you should go back. Are you going to go back? The overwhelming answer that I always get is, no, I've spent such a long time here, I can't go back. I need to make an application to stay within the UK. Now, with this information, with understanding that you do not fall under the immigration rules, we can still make an application under human rights elements where we are saying, you will have significant difficulties in settling back for reasons A, B, C, D, whatever. It could be because of the length of time that you spent here. It could be because you have financial issues. It could be because you have been ostracized from the community or your family or something like that. It could be a number of reasons. If you say that you are at risk of harm, then you have to claim asylum because that is what the law says. But if you say that I will have significant difficulties in settling back, you are falling under the human rights elements, and that is where your private life and your family life will be considered. It will be considered how long you've spent here, how you've spent that time in the UK, and what you've been doing, what your connections are with the UK, what your family ties are, or what your friends' relationships are, how you rely on each other. Is there an extraordinary relationship of dependency between siblings or between adults and parents and things like that? All those things can be considered. So that is about the overstayers. Next, I'm looking at children who have spent 7 years or more in the UK. Now, of course, the immigration rules have a section that covers that. But if you're looking at children, this is again a human rights element. Why? Because what we're saying is that a child that has spent more than 7 years in the UK has spent a significant part of their life in the UK. That means that they have laid down foundations for their life and they should not be taken out. Now, if they have parents living with them and the child is granted status, then under the human rights element, the parents come in as well. And that is how the parents get. So again, the human rights bit comes into this. Next kind of application that happens, the adult dependent relative type application. I call this the ADR type application because adult dependent relatives cannot make applications from within the UK. They have to go back to their country, apply from there. Only then they can make an application within the immigration rules. But if, for example, you have parents who have come over as visitors and you found that there is...
Wow. So you do listen to the video, share the video, like the video, and follow me more for more information about immigration in UK. Thank you. I still remain the global orator, Sapor.